Hey folks, James Abrinio coming to you from Abrinio Cho, your Northern Virginia personal injury criminal defense law firm. It is November 24th, around just before 2 p.m. And I just noticed on Blue Sky some important news. A few days ago, I posted an update about the James Comey case, and talking about the attorney that was installed, Lindsey Halligan, to essentially present to a grand jury. There was a lot of criticisms by the judge in that case, the magistrate judge who's reviewing Mr. Comey's motion for grand jury transcripts and more information from the grand jury. Well, just moments ago, it appears that the indictment against Mr. Comey has indeed been dismissed. I'm going to go ahead and bring this up. And what we're going to do, we're going to walk through the opinion. It looks like a 29-page opinion, so not going to go through every aspect of it, but I figured it would make a lot of sense just to kind of walk through important parts of the opinion, so you can see it firsthand. You're probably going to see a lot of news on it, but again, the purpose of this YouTube channel is to discuss Virginia law and aspects in Virginia. This Comey case, obviously, Eastern District of Virginia. While my firm, again, we're mostly in state court, it's a local news story, even though it's obviously national, and it's historic, given the fact that it's pretty clear that President Trump directed U.S. Attorney Halligan to or Pam Bondi to the DOJ head to indict Mr. Comey last minute. And so this opinion gets into that. So let's take a look. I'm going to go ahead and make this a bit bigger so we can see here. As you can see, it is, and this is filed November 24th. So today, this is James Comey, United States v. James Comey, case number here, opinion and order granting motion to dismiss. And just so you can see, you can go to the end of the opinion. That's how you find out who wrote it. And you have here Cameron McGowan Curry, senior United States District Judge, sitting by designation. So that is who entered the order. And again, this is in the United States, Eastern District of Virginia in Alexandria. If you're familiar with the area, right now, Alexandria. So just to start, there was a quick summary just so we can, so the judge can cut to the chase. September 25th, Lindsey Halligan, a former White House aide with no prior prosecutorial experience. And just to be clear, I want to be clear, the fact that that's pointed out, that's a big deal. Essentially, you can kind of see where the judge is already going with it, and why the judge is critical. A big part of this question is not just about how she handled the grand jury, but whether or not she was properly appointed. And that's going to be a big basis for this motion to dismiss. So getting back to it again, September 25th, Lindsey Halligan, a former White House aide with no prior prosecutorial experience, appeared before a federal grand jury in the Eastern District of Virginia, having been appointed by interim U.S. attorney by the Attorney General, that's Pam Bondi, just days before. Ms. Halligan secured a 2-count indictment charging former FBI Director James Comey with making false statements to Congress and obstructing a congressional proceeding. Obviously, now Mr. Comey moved to dismiss this, and dismiss the ground on the ground that Ms. Halligan, the sole prosecutor who presented the case to the grand jury, was unlawfully appointed in violation 28 U.S.C. Section 546 and the Constitution's Appointment Clause. As I explained below, I agree with Mr. Comey that the Attorney General's attempt to install Ms. Halligan as an interim U.S. attorney for the Eastern District of Virginia was invalid, and because Ms. Halligan had no lawful authority to present the indictment, I will grant Mr. Comey's motion to dismiss without prejudice. Okay, so that is the judge saying no dice here. She was never properly appointed, therefore it's dismissed. Now, you noticed the term of art, without prejudice. What that typically means, what that means in law, is essentially, in theory, the government can rebring a charge when a charge is dismissed without prejudice, meaning it's not a done deal. Now, my understanding of the facts of this case, part of the reason Ms. Halligan was appointed and kind of ran through the grand jury system without anybody to essentially hold her hand was the timing of this. It sounded like the statute of limitations was really running. I want to say, from my understanding, there was only a day or two left. So this was really a last-ditch effort to get Mr. Comey charged. So I suspect from a practical standpoint, the ability for the government to recharge this is effectively nil. But we'll see. Hopefully it stands, but obviously we'll see. So I wanted to go through the opinion again. And so this is page 2 of the opinion. We're not going to get through the details, but legal background. The Appointments Clause prescribes the exclusive means of appointing officers of the United States. The text of the clause contemplates 2 types of officers, and we're not going to get into a lot of this detail, but it's really geared towards the Appointment Clause. Let's see, factual finding. I think this is kind of more easier to digest. On January 25th, Jessica Aber, who was nominated by President Biden, confirmed by the Senate, resigned as position of attorney for Eastern District of Virginia. Following day, the Attorney General appointed Eric Siebert, U.S. interim. Mr. Siebert's 120-day interim appointment was set to expire on May 21st. So on May 9th, the judges of the district exercised authority under their discretion to appoint Mr. Siebert to continue his role effective May 21. Sorry about that. On September 19, Mr. Siebert informed his colleagues of his resignation, and the court is essentially given links to the press release. According to news report, Mr. Siebert had recently expressed concerns of to senior Department of Justice officials about the viability of pursuing charges against Mr. Comey and the New York Attorney General Letitia James. And by the way, as we're reviewing this case, my understanding is the court also dismissed the indictment against Ms. James for the same reason, because I haven't really covered that case on this channel at all. I'll leave you to look that up yourself. We're going to focus on Mr. Comey's case here, but it sounds like that case just got dismissed as well for the same reason. Mr. Siebert's resignation came hours after President Trump told reporters at the White House he wanted Mr. Siebert out, and you can probably presume why. And the next day, President Trump posted and later deleted the following message on social media. And just to be clear, this is the post on President Trump's Truth Social platform, where there was speculation that he actually meant it to be a text to Miss Bondi, to Attorney General Bondi, but he accidentally posted it on social media. And this is the one where the infamous tweet where he's essentially telling her that he wants Mr. Comey indicted. Pam, I reviewed over 30 statements and posts saying essentially that same old stories last time, all talk, no action, nothing is being done. What about Comey and Shifty Schiff, Letitia, ? They're all guilty as hell, but nothing is going to be done. Then we almost put a Democrat-supported U.S. attorney in Virginia with a really bad Republican past. I think he's talking about Siebert. And a woke rhino, apparently that stands for Republican in name only, who was never going to do his job. That's why the 2 of the worst Democratic senators pushed him so hard. I think that is a reference to Todd Gilbert, for you folks following here, Virginia, legislative law. This is channels about Virginia law and current events. Todd Gilbert was appointed as a U.S. attorney. He resigned his elected official position, and then apparently, I think it was like a week later, he ended up stepping down because it sounded like essentially Bondi was ordering him to do things that he didn't want to do, trying to install people that he didn't want to install. So hats off to him for stepping up. But obviously Trump is not happy about that. And Trump is referencing Tim Kaine and Mark Warner, who pushed Mr. Gilbert. He even lied to the media, said he quit. We have no case. No, I fired him. There's a great case, and many lawyers. Let's see. He even lied to the media, yada, yada, yada. We can't delay any longer. It's killing our reputation and our credibility. They must be impeached. They impeached me twice, indicted me 5 times over nothing. Justice must be served now. President Donald J. Trump. and they even linked his social media there. And I just want to be clear, because I think a lot of times as we in the public are experiencing one of the most, I'm going to leave it at unique presidencies of our lifetimes, one of our most unique political errors of our lifetime. I, for one, am often left with thinking, we have a president that can constantly say things that simply have no impact on law and on the law of order and what is just and right. And what this court is saying, if you're going to make these tweets, they're going to matter. And so here you have a judge literally pasting that into their order, dismissing the very indictment that Donald Trump wanted against James Comey. So that's a big deal. I just want to be clear about that. That's a big deal. That is the court saying these facts matter and what Donald Trump says actually matters. And then it goes on. Less than 48 hours after the President Trump's post on September 22nd, the Attorney General issued an order authorizing Lindsey Halligan to be interim U.S. Attorney for the Eastern District of Virginia during the vacancy. And so that's part of it. September 25th, a grand jury sitting in the Eastern District of Virginia returned a 2-count indictment against Mr. Comey, charging him with making false statements within the jurisdiction of the legislative branch, obstructing congressional proceedings. These charges stem from testimony Mr. Comey gave during a Senate Judiciary Committee hearing in 2020. Ms. Halligan was the only prosecutor in the room who participated in the government's presentation to the grand jury. Only her signature appeared on the indictment. And as we sit here today, and there's a footnote that was, I think, making the point that I want to make. The grand jury was originally presented with a 3-count indictment. At some point, however, a second 2-count indictment was prepared. It is unclear by whom, which removed count 1 of the original indictment. Both indictments were signed by Ms. Halligan, and the grand jury foreperson who returned them to the magistrate judge. During the indictment proceeding, the foreperson explained that they did not agree on the very first count, and on the count 2 and 3, they were put in a different package we agreed on. After speaking with Ms. Halligan, the magistrate accepted the return of the second 2-count indictment, instructed the foreperson to annotate the report of the grand jury to reflect that it only applied to count 1. I was actually, before I shot this video, I was going to do a supplement to the video that I did a few days ago about Ms. Halligan's presentation to the grand jury, where I pointed out she's never done a criminal case. There was nobody else in the room. It seems to me that it's becoming pretty clear, or maybe it's already been very clear, that you had no line prosecutor or no prosecutor in that office willing to stand up with her, because the charges in this case were so questionable that I frankly think no attorney wanted to put their name onto it. Okay. We as attorneys, when we sign our names to pleadings, when we make representations to the courts, we have obligations of candor to the court. We are officers to the court. We have an obligation to not present perjured testimony. We have all these ethical obligations. As a prosecutor, they also have ethical duties beyond just what normal attorneys is. And the primary one is to seek justice. What does that mean? That means that you don't present you don't present indictments to a grand jury. You don't ask them to indict individuals unless you have a good faith belief that there is sufficient evidence, probable cause to go forward, and you're going to present that case fairly. How exactly they do that, I'm not a prosecutor. I've never been a prosecutor, but they have ethical duties when they're doing these grand jury cases, because nobody else is in the room. There's no defense attorney to cross-examine. There's no defense attorney to argue why there's not probable cause. So there are special ethical obligations that prosecutors maintain. And from the best that I can tell from what I'm seeing being reported, nobody wanted to put their name on this thing because they were concerned. They should be concerned about the ethical obligations there. And whether it's we'll figure out what that ultimately means for Ms. Halligan. We'll figure out actually how she actually felt. Maybe she believed that there was good faith. Maybe her lack of experience was taken advantage of. Maybe it's just purely political and it's that cynical. But I do think at some point there will need to be questions asked how this happened. But that's certainly important. So let's keep going here. See. And here, the judge is saying, finding it necessary to determine the extent of Ms. Halligan's involvement in the grand jury proceeding, I ordered government on October 28th to submit for in-camera review all documents related to Ms. Halligan's participation before the grand jury, along with a complete transcript of the grand jury transcripts. Upon reviewing the transcripts, I determined that it did not include any remarks made by Halligan before and after testimony of the sole witness. Accordingly, I directed the government to submit transcripts recording all statements made by Ms. Halligan to the grand jury. Again, this is the government kind of playing games, and I think the court is calling them out on it. This is federal court. This is not something, I practice in state court. To be clear, when you present in state court, the judges take it very seriously. But in federal court, it's at a different level. They don't play around, and you can tell that the judge is getting frustrated here. And so he's asked that they direct the government to submit a complete transcript recording of all the statements made by Ms. Halligan to the grand jury. In a notice filed November 5th, the government represented that it produced all material requests. Let's see. All materials requested by the government. Orders in response, government provided transcript to the grand jury. Government requested that the transcription service transcribe the entire recording, which had not been done previously. The new transcript was provided to the government on November 5th. The above items have now been provided to the court in compliance with the order. November 3rd, the government responded opposition to Mr. Comey's motion. Let's see it. Government filed an attorney. Okay. See, also on that day, the government filed in an order from the Attorney General dated October 31 that reads entirety on September 22nd, 2025. I exercise authority vested Attorney General to designate and appoint Lindsey Halligan for avoidance of doubt as to the validity of the appointment by virtue of authority. I hereby appoint Ms. Halligan additional special attorney September 25th and thereby ratify her employment as a special attorney, has the authority to conduct the Eastern District any kind of legal proceeding. In addition, based on my review of the grand jury, I hereby exercise the authority vested in the Attorney General of law. So essentially, Pam Bonnie's trying to essentially cover her butt and I guess also have different types of employments. Let's see, a little bit more procedural posture. And again, you can read this. I'll link this opinion to the actual show notes here. Let's see, now the discussion. Resolving Mr. Comey's motion required me to first determine whether Ms. Halligan was validly appointed. See, if the answer to that question is yes, I need not go any further, and Mr. Comey's motion must be denied. But if no, Ms. Halligan has no authority to present the indictment at the grand jury. Question becomes, what remedies is appropriate? Should the indictment be dismissed? If so, with or without prejudice? And then this is really the court walking through that thought process, and then giving direction as to what they're going to do later in this opinion, what he's going to do in this opinion. Apologies. And apologies, I'm actually reading this as we're going to. I try to get this video up as quickly as possible. Section 546 is unambiguous, begins by authorizing the Attorney General to appoint the U.S. Attorney. Subsection C2, however, imposes a time. Mr. Comey counters that the 546 limits total tenure of Attorney General's appointments to 120 days and therefore precludes additional appointments by the Attorney General after the expiration of 120 days. Accordingly, he argues that Ms. Halligan's appointment was unlawful because the district court possessed exclusive authority to appoint the interim U.S. Attorney. Once Mr. Siebert's appointment by the Attorney General expired on May 21, and the court says Mr. Comey has a better reading of this statute. Preeminent canon of statutory interpretation requires to presume that the legislature says in a statute what it means and means in the statute what it says. So essentially plainlessness or ambiguity of the language is determined by reference to the language itself, the specific context in which the language is used in the broader context. And so it's essentially saying you got to read the statute. And here, Section 546 is unambiguous. A begins by authorizing the Attorney General to appoint the U.S. Attorney for the district. Subsection C2, however, imposes a time limit on the appointment of Attorney General. Expiration date is 120 days. Subsection D then provides for an option of how subsequent interim appointments may be made. If appointment expires after C2 subsection, district court for such district and only the district court may appoint the U.S. Attorney to serve until the vacancy is filled. The text and structure of subsection D in particular make it appointment power clear, shifts to the district court after 120 days, and it does not revert to the Attorney General if a court-appointed U.S. Attorney leaves before a Senate-confirmed U.S. Attorney is installed. So what the court is essentially saying is, look, this isn't rocket science. Really straightforward stuff here. The language is very unambiguous. As discussed, appointment clause allows Congress by law to vest the appointment of inferior officers. The government briefly asserts that not every action in excess of statutory ipso facto violated the Constitution. So they're saying, well, it's not real. Even if it's not allowed, it doesn't violate the statute, the Constitution. And here, Ms. Halligan has not been appointed by the president with the advice and consent of the Senate or through the Congress he is authorized by statute. So an appointment clause a violation has occurred. The next question is what to do. And so, again, you've either got to have Senate confirmation or statutory authority, which neither had. In light of these principles, I conclude that all actions flowing from Ms. Halligan's defective appointment, including securing and signing Mr. Comey's indictment, constitute an unlawful exercise of power and must be set aside. There is simply no alternative course to cure the unconstitutional problem. I'm not going to get into the government's argument as to why that it should be set aside, as the court's addressing. And then it gets into whether or not the dismissal will be without prejudice. Ultimately, I believe the Supreme Court's appointment clause jurisprudence provides that the answer to the with or without prejudice question in both Ryer and Lucia reference the cases the court addresses. The court essentially unwound the actions taken by the constitutional appointed officer and restored the affected party to the position the party occupied before subjecting those invalid acts. The appropriate remedy for adjudication tainted with appointment is violation, now hearing properly appointed official. I will do the same here. I will invalidate the various acts performed by Ms. Halligan. Essentially, they have no effect, and dismiss the indictment without prejudice, returning Mr. Comey to the state he occupied before the indictment. And so there it is. It's pretty straightforward. The indictment is dismissed. Obviously, without prejudice, as the court made clear. The question really is going to be, does the government have enough time to try to bring a new indictment? Frankly, I think that practically speaking, that's just going to be impossible. Who knows with this administration what they're going to try to do. But it'll be interesting to see. But nonetheless, I'm glad that the court reached this decision. It is, anybody practicing criminal law, I represent victims on the civil side as well. But if you've worked in the criminal justice system for any amount of time, one thing that is strikingly apparent is the world is ripe for abuse by government actors. It happens a lot. And so there's just a standard always needing to question what the government is doing in any particular case. But this is a different level where you have a president openly ordering effectively ordering an individual to be prosecuted who is a political foe. And it's clear from that tweet, or whatever you want to call it, that truth, whatever you want to call it, it's clear that this was a vindictive prosecution. And had it not been dismissed for this reason, it would have been interesting to see that litigated. But it was clear that President Trump wanted this prosecution happy. It was clear that Pam Bondi delightfully went along with it, and it was clear that Lindsey Halligan, in my view, was used in order to get this end. Whether knowingly or unknowingly, I don't know. I don't know enough about her. I'm not going to speak on her behalf. But what I will say is, if you are a young attorney out there and somebody's telling you to do stuff that doesn't feel right in the gut, don't do it. It's not worth your license. It's not worth your reputation. Maybe if you're a President Trump influencer and you get a bunch of money, maybe it's worth it to you. Personally, I came to the practice of law because I wanted to help folks, because I believe in the Constitution. I believe in the law, whatever that means. But ultimately, I believe in our system, how flawed it may be. I believe in it. And that's too important for you young attorneys. Power is not worth it. It's not worth it. Maybe there's money coming down. I can't understand why folks are going down that road, but it is what it is. But at the end of the day, if you're like me, you got to look your family in the face and say, did I do the right thing today? And, if somebody's asking you to do something that is unethical, that is unlawful, don't do it. Wish you guys the best. Take care. Be safe. And happy Thanksgiving. Hug your family.